Welcome! We are glad that you are here. This presentation regarding the new Alabama Act 2023-548 has been developed by Melissa Watts and Dina Spinks for Notary Know-How LLC. This bill is a real game changer for our industry and impacts every notary in the state. If you will give us just about 15 minutes of your time, we hope that the following information clarifies any questions you may have. As you proceed through this presentation, you will see numbers such as 1 through 24, 25 through 28, and so forth. These numbers are the line numbers in the bill. In other words, if you print the bill, you can then follow along with the line numbers from which the information is taken. This is a synopsis of the Alabama Act 2023-548, signed by Governor Kay Ivey on June 14, 2023. This act shall become effective September 1st, 2023. It is important to note that all existing notaries public functioning on January the 1st, 2023 shall continue to function pursuant to their existing authority for the remainder of their existing commission. The information contained therein is not to be considered as legal advice. If you have any questions, please contact an attorney or call the probate judge's office of the county in which you were commissioned. Below is a link to the Alabama Act 2023 where you can download and print. The link is also in the video description below. So let's jump right in and look at the overview that is given in the first portion of this bill on line items 1 through 24. This act is to amend the previous Code of Alabama 1975 regarding notaries. It is to provide further for the appointment and services of notaries public, to increase the fee collected by the judge of probate for the commission of a notary, to expand the grounds under which a judge of probate may accept or deny an application for a notary commission, to require an applicant for a notary commission to complete a training program, to increase the bond requirement of a notary public, to provide further for the acknowledgement of signatures, to increase the fee collected for notarial acts performed, and to specify the acts of a notary or other individuals that constitute a crime. The following 3 points are comments in general about notaries for the state at large. First, on lines 25 through 28, we see a competent number of notaries public for the state at large shall be appointed and commissioned by the judge of probate of the several counties of the state and shall hold office for 4 years from the date of their commission. Next, notaries public shall perform all the acts and exercise all authority under the general laws of the state of Alabama. The jurisdiction of the notaries public shall not be limited to the counties of their residence and shall extend to any county in the state. This information can be found on line items 29 through 33. Lastly, on line items 67 through 70, a notary public is not an insurer, but it is under a duty to act honestly, skillfully, and with reasonable diligence. A notary public shall not perform any acknowledgement in any transaction where she or he has a pecuniary interest. From a novice standpoint, when it comes to legal lingo, we were able to break this bill down into 11 main points. The commission fee, found on lines 33 through 43, the application fee and denial of applicant, found on lines 44 through 84, the bond requirement, found on lines 85 through 99, the seal and signature, found on lines 100 through 110, physical appearance and identity of the signer, found on lines 111 through 183, the notary fee, found on line item 184 to 198, violations of this article, found on line items 199 through 205, A Class C misdemeanor found on line items 206 through 226. A Class D felony found on lines 227 to 243. Notarial misconduct resulting in an investigation found on line items 244 through 266. And last, number 11, injunctive relief and surrender of your seal found on line items 267 through 280. Meet Wes Allen, Alabama's Secretary of State. Although you are commissioned by the probate judge of the county in which you reside, the Secretary of State is the governing body over notaries. The first change we see in this bill that is taking place is mentioned on line items 33 through 43. There will be a $25 commission fee for each notary commissioned. Previously, each county set their own commission fee. In addition, the judges of probate shall also report to the Secretary of State the name, county of residence, date of issuance, and date of expiration of the commission of each notary public appointed and commissioned under this subsection. Line items 44 through 84 detail the application process. There will now be a $10 application fee. A judge of probate may accept or deny any applicant. Grounds for denial are as follows. An applicant is not a resident of the state. An applicant is not a resident of the county in which they applied. An applicant has been convicted of a felony or a crime of moral turpitude. An applicant is currently a debtor in a bankruptcy proceeding. An applicant is under a current order adjudicating him or her incapacitated. An applicant provides false information on the application. And lastly, if an applicant is unable or unwilling to complete a training course within 30 days after submitting his or her application. This time frame may be extended by the judge of probate upon good cause shown. In addition, this section addresses a new training program required for all notaries. Before being commissioned, an applicant for a notary public commission shall successfully complete a training program prepared by the Alabama Probate Judges Association and the Alabama Law Institute that reinforces and updates the applicant's knowledge of all matters relevant to the appointment, authority, duties, and legal and ethical responsibilities of a notary public. An attorney who is commissioned as a notary public under this article is not required to complete the training requirement. A $50,000 bond is to be purchased from an Alabama insurance producer. Notaries public shall give bond with sureties obtained from an Alabama licensed producer of such bonds to be approved by the judge of probate of the county of their residence in the sum of $50,000 payable to the state of Alabama and conditioned to faithfully discharge the duties of the office so long as they may continue therein or discharge any of the duties thereof. The bond shall be executed, approved, and recorded in the office of the judge of probate of the county of their residence before they enter into the duties of their office. This information is found on lines 85 through 98. Notary Know-How is an Alabama licensed insurance producer. You may purchase your bond by going to our website at www.notaryknowhow.org and clicking on the Bond and E&O Insurance tab. This next section covers information regarding your seal and signature on documents that will be publicly recorded. Recorded public documents must contain both the notary's signature and seal. For the authentication of his or her official acts, each notary shall provide a seal of office, which shall present by its impression or stamp the name, office, and the state for which he or she was appointed. The form and content of any notarial act on an instrument to be recorded in the public records, including the court system, shall include an oath acknowledgement, and signature of each party to the document, or his or her mark and the signature of the notary public and their seal of office by either ink stamp or embossed impression. The physical appearance and identity of the signer. This section of Act 2023-548 is the longest section and covers the physical appearance of the signer to the notary and can be found on lines 111 through 183. The signer must physically appear to the notary either in person or via a two-way audio-video communication to assure the identity of the signer. In addition to details regarding the physical appearance of a signer before you, this portion of Act 2023-548 discusses in detail what we call RIN, or Remote Ink Notarization. This is not to be confused with what we refer to as RON, or Remote Online Notarization. At this time, the state of Alabama does not approve remote online notarizations. During COVID, Governor Kay Ivey signed into law the use of remote ink notarizations. It is very important for you to understand the difference. On the main page of our website, you will find an easy-to-read chart that compares the two side by side without all the legal jargon. The following slides quote word for word lines 111 through 183 of Alabama Act 2023-548. Except as otherwise provided in this section, any signature acknowledged by a notary public shall be executed within this state and shall be executed in the physical presence of the notary public at the time of the acknowledgement, only after the notary public has positively identified the prospective signatory via personal knowledge of the affiant or the examination of photo identification issued by a governmental entity or agency. For the purposes of this section, the following terms shall have the following meanings: original signature, a signature signed directly onto a document in wet ink by an individual who is named on a document. Signatory, the individual who is named on the document and is to sign the document. Unless otherwise provided by law, the powers and functions of a notary public require his or her original signature. For purposes of this article, an individual may personally appear before an acknowledging notary by either of the following: 1. Physically appearing before the notary as provided in the previous section, or 2. Appearing through the use of a two-way audio-video communication technology that allows a notary public and a remotely located signatory to communicate with each other simultaneously by sight and sound, provided that the notary public is physically located in this state and the two-way audio-video communication is recorded and maintained for a period of 7 years by the notary public. If appearing through the use of two-way audio-video communication, the identity of the signatory shall be verified by the notary public using either of the following methods: the personal knowledge of the notary public of the identity of the signatory, the presentation of two forms of government-issued identification, one of which shall include the face and signature of the signatory, and a process by which the notary public verifies the identity of the signatory through a review of public or private data sources. The two-way audio-video communication recording shall contain all of the following: the date and time of the remote notarial act, a description of the documents to which the remote notarial act relates, an attestation by the notary public of being physically located in this state, a description of how the identification of the signatory was verified, a clear image of any government-issued identification if applicable, a clear image of the act of signing observed by the notary public. The official date and time of the notarization is the date and time the notary public witnessed the signature, including the date and time the signature was witnessed by a two-way audio-video communication technology. All documents used during the two-way audio-video communication shall be provided to the notary for his or her authentication and original signature. Any action taken before July 1st, 2021, allowing for the remote notarization of signatures under the Emergency Management Act of 1955, Article 1 of Chapter 9 of Title 31, is ratified and confirmed. Remote notarization may not be used to notarize an absentee ballot application or an absentee ballot affidavit, or for any purpose related to voting. Although not mentioned in Act 2023-548, I do want to point out that at this time, the state of Alabama does not approve remote ink notarizations for marriage certificates either. Smile! Go ahead. Smile. You'll feel better. I felt like after all that heavy reading, you needed to take a minute and just smile. Smile and remember why you became a notary and the incredible positive impact these changes are going to have on our industry. So let's continue. The notary fee. We are so excited to tell you that the fee you will be allowed for each notarial act has now been changed from $5 to $10. A notary public commissioned pursuant to this article is permitted a reasonable fee not to exceed $10 for each notarial act performed. No fee may be charged by a state, county, or municipal employee for a notarial act performed during and as a part of his or her public service unless otherwise provided by law. This information is covered on lines 184 through 198. Line items 199 through 205 discuss the probate judge's response to a notary that violates any portion of this article. The commissioning judge of probate, or his or her successor in office, may issue a warning to a notary or restrict, suspend, or revoke a notarial commission for a violation of this article, and on any ground for which an application for a commission may be denied under this article. A period of restriction, suspension, or revocation does not extend the expiration date of a commission. The next two sections cover what would be considered a Class C misdemeanor and a Class D felony. More than likely, you will never need to know the following information. Nonetheless, we do need to go over the consequences for notarial misconduct because the repercussions are quite serious. Except as otherwise permitted by law, an individual who commits any of the following acts is guilty of a Class C misdemeanor: holding oneself out to the public as a notary without being commissioned, performing a notarial act with an expired, suspended, or restricted commission, performing a notarial act before taking an oath of office, charging a fee for notarial acts in excess of the maximum fee allowed, taking an acknowledgment or administering an oath or affirmation without the principal appearing in person before the notary or following the procedures for remote ink notarization set out in this article, taking an acknowledgment or administering an oath or affirmation without personal knowledge or satisfactory evidence of the identity of the principal, taking a verification or proof without personal knowledge or satisfactory evidence of the identity of the subscribing witness. This information can be found on lines 206 through 226. This act further clarifies in detail the unlawful actions of a notary that would be considered a Class D felony. A notary is guilty of a Class D felony if he or she does any of the following with the intent to commit fraud or to intentionally assist in the commission of a fraudulent act, takes an acknowledgment or a verification or proof or administers an oath or affirmation he or she knows or reasonably believes to be false, takes an acknowledgment or administers an oath or affirmation without the principal appearing in person before the notary or without following the procedures for remote ink notarization set out in this article, performs notarial acts in this state with the knowledge that he or she is not properly commissioned under this chapter. This information can be found on line items 227 to 243. Part of being a notary is being a person of integrity, honesty, and character. And I truly feel that no one who has taken on the weighty responsibility of this profession would conduct themselves in an unworthy manner. However, we must be prudent in examining notarial misconduct. Let's look at the last two sections of Act 2023-548. Certain acts of notarial misconduct may lead to an investigation. Any party to a transaction requiring a notarial certificate for verification, and any attorney licensed in this state who is involved in such a transaction in any capacity, may execute an affidavit and file it with either the Secretary of State or the Judge of Probate, who issued the commission to the notary public, setting forth the actions which the affiant alleges are violations. Upon receipt of an affidavit, the Secretary of State or the Judge of Probate shall forward the affidavit to the Alabama State Law Enforcement Agency. Upon receipt of the affidavit, the Alabama State Law Enforcement Agency shall initiate and carry out on their own or in coordination with local law enforcement agencies investigations or violations. Founded investigations shall be referred to the appropriate district attorney for prosecution. Resignation or expiration of a notarial commission does not terminate or preclude an investigation into the conduct of a notary by the Secretary of State, a judge of probate, or a law enforcement agency who may pursue the investigation to a conclusion, whereupon it may be a matter of public record whether or not the finding would have had grounds for disciplinary action. Furthermore, notarial misconduct may lead to injunctive relief and/or surrender of your seal. The commissioning judge of probate may order injunctive relief against any individual who violates this chapter, including, but not limited to, ordering the surrender and destruction of a notary commission and a notary seal. Any individual who knowingly solicits, coerces, or in any material way influences a notary to commit official misconduct is guilty as an aider and an abettor, and is subject to the same level of punishment as the notary. Although this bill would have as its purpose or effect the requirement of a new or increased expenditure of local funds, the bill is excluded from further requirements and application under Section 111.05 of the Constitution of Alabama of 2022, because the bill defines a new crime or amends the definition of an existing crime. Thank you so much for joining us. We sincerely hope that we were able to break down and explain in clear terms the new Alabama Act 2023-548 for you. If you've enjoyed this training, go to our website for a full list of all our training videos and blogs. See you in the next class.